Right, this is the second in my series of intermittent podcasts during lockdown. Today is the 70th anniversary of the Schuman Declaration. This is a statement made by French Foreign Minister Robert Schuman on the 9th of May 1950. It proposed to place French and West German production of coal and steel under one common authority. This organisation would be open to the participation of other Western European countries. And we know what that led to. So, it seems appropriate to devote some attention to Brexit again. We all know that we left the EU at 11 p.m. on 31st of January. Goodness, what a different world that was. Anyway, that's not the really important date. We are currently in the waiting room to leave, a sort of legal equivalent of purgatory, still subject to EU laws, still subject to the rules of the single market, still participating in EU treaties, but not participating in EU institutions, so P45s have been given for all our MEPs. We are now in the implementation period. It ends on the 31st of December 2020. During this time we shall endeavour to negotiate a new trading agreement with the EU. It doesn't seem to be going so well at the moment, but there is the possibility of an extension being sought, and that has to be done by the end of June. The EU Withdrawal Act categorically rules that out, so it looks likely that on the 1st of January 2021 the UK will wake up to the hardest of hard Brexits as it starts a new life as a third state. So what about shipping law? I've got here the 6th edition, plug, of my book. What am I going to have to change for the next edition? Very little, I'm relieved to say. EU law has very little impact in this area. Hague rules, collision regulations, York Antwerp rules, nothing to do with the EU. But there is one chapter I will have to tweak. Chapter 18, Jurisdiction, Arbitration and Applicable Law. The first and last of these topics are very much affected by EU law, but not arbitration, where enforcement of awards falls under the 1958 New York Convention. For jurisdiction, there is the Brussels Regulation recast on jurisdiction and judgments. For choice of law, there are the two Rome Regulations on applicable law in contract and for non-contractual obligations, Rome I and Rome II respectively. Under the EU Withdrawal Act, all regulations will become converted into domestic UK law on exit day. Now that's going to stay the position with Rome I and Rome II, but it is not going to be the position of the Brussels regulation though. Scaffolders are way at work over there opposite my house. A statutory instrument, the Civil Jurisdiction and Judgments Amendment, EU Exit, Regulations 2019 number 479, provides that the provisions of both iterations of the Brussels Regulation and of the Brussels Convention that preceded them, and also the Lugano Conventions, will cease to have effect under UK law on exit day. So, unless there is a new agreement on jurisdiction with the EU, it'll be back to the common law. So, a UK company gets sued in the High Court, it'll now be able to apply to have proceedings stayed on grounds of forum non convenience. The effect of the SI is dormant at the moment due to the implementation of the withdrawal agreement with the EU, but it will kick in on the 1st of January 2021. There's also another SI which has similar effect with regard to the EU Insolvency Regulation and its 2017 recast iteration. That will be very relevant to the exercise of liens on subfreights, where you have a charterer domiciled in an EU state that is insolvent. But that's a story for another day. The UK government's position on civil jurisdiction has been to apply to join the 2007 Lugano Convention. This applies an inferior version of the recast Brussels regulation, the original 2001 version, and it applies it as between the EU and 3 third states, Iceland, Norway, Switzerland. It also requires the courts of those states to take account of the decisions of the ECJ, something which may stick in the craw of some members of Mr. Johnson's party. The admission of new members to the club requires the consent of all existing members. The third states are happy to let the UK in, but quelle surprise, the EU is currently indicating that it will not consent. So, will we be out in the cold jurisdictionally on the 1st of January 2021? Not quite. There is the Hague Convention of 2005 and choice of court agreements. The convention deals with exclusive jurisdiction clauses in favour of a contracting state and for the recognition and enforcement of judgments within contracting states in respect of contracts with such clauses. The parties to this convention are currently the EU, Singapore, Mexico, Denmark and Montenegro. The UK is currently party to this through its former membership of the EU. To cater for the possibility of an exit from the EU without a withdrawal agreement, the UK government, just after Christmas 2018, decided to give the necessary 3 months' notice of its intention to accede to the convention in its own right in time for 1st of April 2019, which is the date when we were originally scheduled to leave the EU. Various extensions are subsequently made, and then when the UK finally did leave at the end of January of this year, the UK, on the 1st of Feb, withdrew its accession. Doubtless it will re-accede by the end of September, 3 months before the end of the implementation period. The convention is better than nothing, but there are some notable exclusions. The convention, for example, does not apply to contracts for the carriage of goods or passengers, although it would apply to contracts by way of time charter or demise. Also excluded are insolvency, composition and analogous matters, marine pollution, limitation of liability for maritime claims, general average and emergency towage, and salvage. Antitrust matters, competition stuff, liability for nuclear damage, hope that never happens, claims for personal injury brought by or on behalf of natural persons, tort or delict claims for damage to tangible property that do not arise from a contractual relationship. So some significant exclusions. 52 days to go till the last opportunity to seek an extension to the transition period. Then a further 6 months till the UK becomes a fully fledged third state. Something new to talk about in our Zoom talks over Christmas, apart from coronavirus. So, thank you for your attention, and there will be more short recordings going up in the course of time.